We are going to talk today about the Coty and Amazon case. So we'll start with just going through some of the background facts. Then Ollie's going to talk about the background law on liability of platforms and marketplaces. Then we'll talk through the case, so the national proceedings, the Advocate General opinion, finally the Court of Justice judgment, and then we'll talk a bit about the implications for brand owners. So what enforcement options do brand owners still have, and where might the law go from here? So the case that we're talking about is Coty, Germany and Amazon, and specifically the Court of Justice judgment of last month. And this was all about this product, which is pictured on the slide here. So it's Davidoff hot water perfume. Now, Coty Germany is a licensee of the EU trademark for Davidoff and a distributor of Davidoff perfumes. It discovered back in 2014 a seller on Amazon who was offering the Davidoff hot water perfume for sale on the Amazon marketplace section of the German website. Now, I'll just move on to this next slide. So the seller was using the fulfillment by Amazon scheme, which you can see on the slide here. There's some details of it. It's basically an Amazon scheme where the contract for sale of the goods is between the third-party seller and the purchaser, so it's not between Amazon. But basically, Amazon does a lot of the rest of the stuff. So I don't know if you can see on the slide, they might be a bit small, but you can see at the bottom here, they say, simply send us your products and we take care of storage, delivery to customers, customer service and returns handling. Yeah, so they're doing a lot of stuff here. And you can see right at the bottom here, they're talking about it as being the heavy lifting. So even though the contract for sale is between the third-party seller and the purchaser, Amazon has quite a big role to play. So back in May 2014, Coty identified this seller who was selling the Davidoff hot water product, thought the product was suspicious, so they did a test purchase. When they got the goods, they found that they were so-called grey goods or parallel imports. Now, I'm sure most of you know what that is, but just as a reminder for anyone who doesn't or needs a recap. So they weren't fake goods, they were legitimate, genuine Davidoff goods, but they had only been authorised for sale outside of the EU. The trademark owner hadn't consented to them being on the market in the EU, so they shouldn't have been on sale on the German Amazon site. So, in June 2014, Coty requested that Amazon return all bottles of perfume bearing the Davidoff mark that were stocked on behalf of the seller that it had identified. Amazon agreed to that and sent back 30 bottles, and Coty discovered that 29 of them were grey goods. They also found out that 11 of the goods had been stocked on behalf of a different third-party seller, so not the original one that they had seen on Amazon, but a different third-party seller altogether. They asked Amazon to disclose details of the other seller, but Amazon refused. And it was at this point that Coty had clearly had enough and decided to issue proceedings against Amazon. So we'll obviously go into the details of those, but before we do that, Ollie's just going to talk through some of the background law relating to liability of platforms and marketplaces.
Thanks, Jo. So Jo, do you mind muting? Thank you. So these are the main trademark rules that are applicable here. So the starting point is to consider on what legal basis a platform or a marketplace could be liable, given what Jo said about it not being the actual seller. Under EU law, that's working fine apparently, that's good. Under EU law, there could be a variety of answers. So, for example, under trademark law or copyright or design law. This case concerned trademark infringement, so we'll keep it to that in order to keep to the time estimate. So the key provisions to look at are the EU trademark directives and the regulations, also the IP enforcement directive and the e-commerce directive. This case straddles the reforms to the EU trademark rules that happened in 2017. So you can see there that we've covered the 2009 and the 2017 regulations. The old and the new provisions are pretty much identical, so we don't need to really worry about that. They both give the holder of an EU trademark the exclusive right to prevent third parties from using, in the course of trade, a sign that is identical or similar to the trademark in certain circumstances. So here's the exact wording of those two provisions, because it's always useful to go back to the actual law. This case concerns what we call double identity infringement, i.e. it was the actual identical trademark was being used, as Joe said, it's genuine products, for the actual product that the trademarks were registered for. That's as close as trademark law comes to strict liability infringement. Then Article 9.3 gives a bit of flesh on the bones of that using the course of trade point. And it provides a non-exhaustive list of acts that would be prohibited. And one of those, and the one that we're concerned with today, is the offering the goods, putting them on the market or stocking them for those purposes under the sign. So it's that stocking them for those purposes that is going to be really important in this case, and we'll come back to that. Now, Coty alleged that Amazon's marketplace, supported by its fulfilled by Amazon service, used the Davidoff mark. So this is not the first time that that anyone's had a pop at marketplaces, and as we'll discuss, it won't be the last. The key sort of provisions and the key case law that the court referred to in this was L'Oreal and eBay, which is certainly the leading case in this area. So that was it was a fairly pro-platform decision where the ECJ had held that it was the seller that used the trademark and not the operator of the website. So where there were infringing goods on eBay, it wasn't eBay that was liable for that for those sales. Similarly, the ECJ found in Google's favour in Google France, finding that Google didn't use the trademarks when traders were bidding on AdWords. So if you search for L'Oreal as an example in Google, it's not Google that's responsible for that ad. Stepping away from platforms, because there are some relevant ones. There's this one which I'll refer to as Winters for obvious reasons. This was a manufacturer that was adding a drink to a can, and the exterior, or the actual can itself and the advertising of it was at least arguably infringing the Red Bull's marks. But because of the brand behind that was based in the Cayman Islands, I think it's the Cayman Islands, the Red Bull went after the manufacturer. But in that case, it was found that the manufacturer that added the contents didn't use the mark. And another one which certainly appears pretty relevant to this case is TOP Logistics, and that was where a bare sort of straightforward warehousing service does not constitute useful trademark. So that's some of the sort of background cases, and you can see generally it's difficult to fix liability to an intermediary service provider is probably a good sort of way of describing it. Then there's also some legislation on this aside from the trademarks law. So that's the e-commerce directive is the biggest one here. So Article 14 is that platform operators are not liable for unknowing infringements, so where they're not they don't know that this thing is going on. And Article 15 prohibits the application of any kind of monitoring obligation to platforms. And this is interesting because that's something that's being rode back on a little bit in EU law at the moment, where the new copyright directive is actually placing on user-generated content sites an obligation to do a little bit more in that regard. So back over to Joe now for her to talk about the early stage of these proceedings.
Thanks, Ollie. So, as I said earlier, Coty issued proceedings in Germany against Amazon for trademark infringement, having not been able to get where they wanted to be, having requested the information from Amazon. They argued that Amazon was using the trademark when they were doing the activities of stocking the goods on behalf of a third-party seller. Unfortunately for Coty, the German court, both at first instance and on appeal, disagreed with them. So the German courts ruled that Amazon didn't stock the perfumes for the purposes of offering the goods or putting them on the market. It had merely stocked the goods on behalf of third parties. So that meant that Amazon's actions weren't prohibited under Article 9.2b of the CTM regulation or 9.3b of the EU TM regulation. It's worth just saying here that both provisions were talked about in the case because the actions took place before the EU TM regulation came into force, but it was also forward-looking for what Amazon's actions would be going forward. So that's why both provisions are cited, but the court said that they are the same thing, and the wording is exactly the same. So the wording is what's on the slide there. So offering the goods, putting them on the market, or stocking them for those purposes under the sign, or offering or supplying services thereunder. So the German court said Amazon wasn't doing that, and so dismissed the action and then the subsequent appeal. So Coty then further appealed on a point of law to the Federal Court of Justice in Germany, and the appeal was on the interpretation of those articles we've just talked about. The German Federal Court decided that it needed further help in interpreting this point, and so referred this question to the Court of Justice. And I'll just read out the question now. So does a person who, on behalf of a third party, stores goods which infringe trademark rights without having knowledge of that infringement, stock those goods for the purpose of offering them or putting them on the market if it is not that person himself, but rather the third party alone which intends to offer the goods or put them on the market? Now, Ollie's going to talk a bit more about why the wording of that question is significant, but just looking at it now, I think anyone who didn't know the facts of the case or the background of the case, I think you wouldn't guess that it was Amazon being described there. It's a very narrowly worded question, and it doesn't really describe the activities that we talked about earlier, the fulfillment by Amazon scheme. It makes it out to be simply a warehouse. So, as I said, Ollie will talk a bit more about why that's significant, but it's just worth just noting now. The other point to note in the appeal was that it was only 2 Amazon parties to the appeal. So in the original proceedings, there had been other Amazon entities that had been involved in operating the website and promoting goods. But because of it was just an appeal on this particular point of law, it was just Amazon Services Europe, which operates the Amazon Marketplace, and Amazon FC Graben, which was the entity that runs the warehouse where the goods had been stocked. I'm now going to pass over to Ollie again to talk about the Advocate General's opinion.
Thank you. Thanks very much. So I have a sort of twitch of always referring to the Attorney General rather than the Advocate General, and I'm going to preempt that by just say that I forever do that, so I'll try not to do that. So the Advocate General advised the court to rule that where a marketplace is not aware of the infringing character of the goods, and they don't intend to offer or put them onto the market themselves, and there's no liability. But the important caveat to that was that the Advocate General made it was a little bit more aware of the background and was willing to take account of the background and the fact that, as Joe said, that question was very narrowly worded, and we all know we're talking about Amazon here, and everyone knows Amazon, and Amazon is not just a simple warehouse. One of its great strengths is that it does a great deal more than just warehousing and dispatching products. I wouldn't expect you to necessarily go through this, but this is the point that Joe said, that Amazon does the heavy work. It advertises the fact that it does everything. All you have to do is you just bring the leadership. I mean, I'm not quite sure what that means, but you bring the product, you bid on the particular ASIN to sell the product, and everything else is done by Amazon. The Advocate General focused on the fact that Amazon offers a completely integrated store where it provides active support in the selling process. It advertises the goods. It enables very complex searching. It recommends products based on their search and their shopping history. It stocks the goods. It packages them up for transport in its own branded packaging. It dispatches them, processes the payment. It takes the money and then passes it on, and it even offers refunds and processes those refunds. That is not a straightforward warehouse. The Advocate General sort of went a little bit further and pretty much seemed to suggest that Amazon would owe some duty of care, and I think this is where the real crux of this is how much can you expect Amazon, which is by its very nature a huge business that provides a service that I think at the moment we're all very grateful for. How much can you expect Amazon to really be monitoring everything? The flip side of that is, as a brand might say, is, well, if you want to open up a web shop and you want to operate everything and you want to package it all up and make it all very easy to sell, you should be making sure there's nothing in there that doesn't infringe. And I think that's where the balance is here. And I think as we go through, the Court of Justice essentially just ducked that question. It wasn't the right case, mainly I think because it wasn't the right question for it to tackle that head on. And while the Court of Justice did accept some of the findings of the Advocate General, it didn't go quite so far. So now, this is all, those of you that read Court of Justice judgments regularly, there is always a slightly wordy bit about admissibility in a lot of cases. The key point here is that Coty said the question was just so wildly out of context. As Joe said, you wouldn't know that was Amazon if you would ask it. But it was essentially hypothetical, and the Court of Justice doesn't really like hypothetical questions. But the court said that it was admissible, and that it was a valid question of law to ask, and it did relate to those proceedings, so it was fine. The court said that it was bound to answer the question that was asked, but not to go any further, and I think that's where it departed slightly with the Advocate General. And it also pointed out that the other Amazon Group companies that run other elements of the Amazon service weren't anymore in the proceedings because of they dropped out at the stage of the appeal. The reference that had been made to the court had made clear that the two companies that Joe mentioned, the Amazon Services Europe and Amazon FC Graben, to quote, nearly stored the goods concerned without themselves offering them for sale or putting them on the market. And secondly, they didn't intend to offer those goods for sale or put them on the market either. So the question was so very narrow that the court really couldn't take into account very much more of the Amazon business. There have been various decisions, some of which I mentioned before, that using a trademark required an active behaviour and direct or indirect control of the act constituting use. So this is that element of, is it fair to find someone liable for something they haven't really done? And the key bit is whether the defendant has used the mark for its own commercial communication, which is a point we'll come back to later, and is interesting for brands litigating in the UK because there has been consideration of this in the past as against Amazon. The nature of the question had been pretty unequivocal, and the Advocate General tried to look beyond that and take the opportunity to clarify the law, but the court has declined that opportunity. So the ultimate answer was no. A person storing the infringing goods on behalf of a third party does not, in the absence of any knowledge of infringement, stock the goods for the purpose of putting them on the market. No use, so there's no infringement. Despite Coty asking for the court to rule on whether Amazon would have got protection from Article 14 of the e-commerce directive, or whether it should be regarded as an infringer for the purpose of the IP enforcement directive. Now that is because that directive requires member states to allow for injunctions to be granted against infringers. So if Amazon, despite not infringing, was an infringer, then it could be subject to an injunction, which but the court declined to rule on that. There was a real sense, I think, that the court was trying to just answer the bare minimum, I think, of what was being asked of it. So we feel like it was a bit of a missed opportunity from a brand perspective. The court didn't really consider the wider business, whereas the Advocate General had, and ultimately the question doesn't answer the question of whether Amazon can be liable for infringements of IP rights by marketplace sellers. So it could well be liable if a court was willing to find that Amazon was also pursuing the aim of offering the goods for sale or putting them on the market. Now, this is an interesting thing, as I said, from the UK perspective. So there was a case that Silkin acted on. Cosmetic Warriors is the owner of the brand Lush, so Lush Cosmetics, which I'm sure many of you will know about. And they sued Amazon for Amazon's sale of a third-party product, by a third-party bath bomb. Don't need to get into it. And the judge in that case, finding in favour of Lush, took all of the different categories of infringement. So there were direct sales. When you click on the sale, it's sold by and dispatched by Amazon. That's a direct sale. And there's the sold by third-party seller, but fulfilled by Amazon, which is what this case concerns. And then there's a third category, the sort of marketplace, where the marketplace seller deals with everything. It's more like eBay. And the English court said that they were just all mixed up. And importantly, and the bit that I've underlined here, is the display on the website is part of its own commercial communication within the meaning of L'Oreal and eBay. So in that case, there is, and this wouldn't be binding on future, it's quite persuasive, that in English law at least, when applying the directive, there is some support for finding that Amazon could be liable. And as I said, the key would be to finding that Amazon was also, that this was Amazon's own commercial communication. But there is a great deal of uncertainty there, and while uncertainty is not necessarily good for brands in this sense, and there can be some value to uncertainty because it can encourage Amazon to do more. That we've not got a sort of clear answer, I think, on this. So I'll just hand you back over to Joe.
Thanks, Ollie. So, as Ollie said, a bit of a missed opportunity, really, from the Court of Justice there. So, where does it leave brand owners in terms of enforcement options? What can you still do to enforce against infringing products that are on marketplaces? The answer is, there is a lot you can do, although, the fact that Amazon has avoided liability in this case means that the onus is still very much on the brand, and ironically, the best way of tackling the infringing product is to work with the marketplaces rather than against them, as Coty tried to do. So, one of the very useful tools that brands have now is the Amazon Brand Registry. Now, this wasn't in place when the Coty case originated. So it was launched in 2017. And a lot of you will be familiar with issuing takedown notices, where you ask a marketplace or a website to take down infringing products. Amazon Brand Registry essentially does that, but with quite a lot of added extras. So it has quite powerful search tools. You can search in bulk. So if you've got a product that you think is infringing, you can search for all the connected products and then make bulk submissions. So it is quite a useful tool, and generally Amazon tend to apply it quite generously. They tend to be quite pro-brand, so it can be very useful. In fact, they say that they, just looking at the statistic, they claim to have stopped over 3 billion suspected bad listings before they were even published to the store. So you can see it is quite a useful tool from that point of view. And as part of the brand registry, they last year launched what they call Project Zero. You can see the strap line on the slide there. So leverages the combined strengths of Amazon and brands to drive counterfeits to zero. Now that's a pretty bold claim, but I think their aim is that they want to eliminate all counterfeits on the Amazon site. So it takes the brand registry service that step further. So it involves automated or proactive scanning. So it uses Amazon's machine learning technology to kind of scan the marketplace automatically and remove infringements. It also offers a kind of self-service removal option, whereby brands, you don't have to submit your request to Amazon in the usual way and then Amazon have to act on it. You can just do it yourself, service option. And there's also a product serialization option, which so brands can give all of their legitimate products a serial number, and then anything without a serial number will be taken down as an illegitimate product. So you can see that we have come quite a step forward in terms of the way Amazon operates since the Coty case originated. But the onus is still very much on brands, and that was why the Coty case was a bit of a missed opportunity, because that would have put more of the onus on Amazon itself. But as I say, it is still a very useful tool, and we have come quite a long way since 2014 at the start of the Coty case. So if you're looking at eBay infringements, then the program there is the Vero program, the Verified Rights Owner program. It doesn't have all the kind of added functionality of the brand registry. It's kind of a standard takedown service. A lot of brands use these tools alongside kind of automated web scraping tools, so similar to the Project Zero technology, but across the whole of the web. So they crawl the web and identify infringements, and that really helps to quickly identify infringing products and help brands to identify where to focus on and things taken down. And then another option, I mentioned at the start that the Coty case started with Coty trying to get from Amazon the details of the other third-party seller that was selling the parallel imported Davidoff products. And Amazon refused. Now, I don't think they took any steps to try and get those details. I think they went straight for issuing trademark infringement against Amazon. But one option could be to get a disclosure order against the marketplace. So in the UK, we refer to it as a Norwich Pharmacal order, to get those seller details and then take action against the seller rather than against the marketplace. Now, I've been focusing so far on enforcement tools when there are products on marketplaces, because that was the scenario of the Coty case. But where there are products on other websites, there's a whole host of things that you can do. So I've just listed some of them here. So a domain name transfer of the website, so you get the domain to your name. You can take action via payment processors. So this symbol here is the IACC roadblock scheme, which a lot of the big payment processors are involved in it, so Visa, MasterCard, PayPal. So you essentially you take away the payment facilities from a website. So if people can't pay for the goods, then they can't sell counterfeit goods or parallel imported goods. You've also got the option of issuing a takedown notice to the website host to get the website taken down. And there's the option of a blocking injunction against the internet service provider. So this came from the Cartier case, whereby if you've got a website that's selling infringing goods, the ISP can be ordered to block access to that website. And then finally, you've got law enforcement agencies. So in the UK, it's PIPCU, and they will sometimes get involved, where there's a serious criminal element in trying to get products taken down. So obviously, it's very unlikely that you're going to get a blocking injunction for blocking access to Amazon. So this isn't going to help you in those scenarios. But where you've got websites where the entire focus of the website is to sell infringing goods, then some of these options are pretty useful. So that was just a quick rundown of some of the enforcement options that you have currently based on the law as it currently stands. And that just leaves the question of where do we go from here? Where might the law take us on liability of marketplaces? Is there potential for Amazon to eventually be found liable? And I think the answer is yes, there is certainly that potential, even without a further Court of Justice reference. So there is the potential for liability under the IP Enforcement Directive. So obviously the Court of Justice ruled that there was no liability under Article 9 of the CTM regulation or the EU TM regulation. But they specifically said at paragraph 49 of the judgment, where an economic operator has enabled another operator to make use of a trademark, its role must be examined from the point of view of other rules of law. For example, whether the activity would fall within the hosting exception, and if it doesn't, whether Article 11 of the IP Enforcement Directive would apply. So even in the current German proceedings, there is still a chance that the court could find Amazon liable under the IP Enforcement Directive. I mean, it seems very unlikely based on the history of the proceedings, but it is still open to them to find that. And importantly, it's open to other national courts in the future to find Amazon liable under the IP Enforcement Directive. And it is also open to national courts in future to find Amazon liable under the Article 9 of the EU TM regulation if they find that Amazon was also pursuing the aim of offering the goods for sale or putting them on the market. As Ollie said, the finding of the Court of Justice was very much based on the rule that the finding of the German National Court that Amazon hadn't been pursuing that aim. But if a national court in future found that they had been, then there is definitely the chance that they could find Amazon liable even without a further Court of Justice reference. So I'm just being asked a question here. I'll just come to the end of the slide and then I'll address that question. So there's potential for liability under the IP Enforcement Directive and also under Article 9 of the EU TM regulation. And then under English law, there's potential liability as joint tortfeasors. Now, I'm not sure how much this has been explored, but going back to the CBS and Amstrad case from 1988 with the dual cassette decks, the question would be, is the marketplace acting in concert with the infringer pursuant to a common design in the infringement? Arguably, yes. If you look at the Amazon fulfillment by Amazon scheme, if Amazon is doing a lot there, is there a common design to put the goods on the market? Yeah, I think it's arguable that there is. It doesn't have to be a common design to infringe. It's just a common design to do the acts that end up infringing. So I think, it's certainly arguable. And it's one way the law might be pushed. Actually, I will come to the end. This is my last slide, and then I will address the question. So yeah, there is potential for liability even without a future reference, but obviously there is still a chance that there might be another reference in future. So as Ollie said, the answer from the Court of Justice was very much dependent on the way that the question was framed. So it's certainly possible that a differently framed question would give rise to a different answer on liability. And then finally, just one other option is the possibility for broader takedown obligations in future. So there was a case of Pieciek, I hope I'm pronouncing that properly, against Facebook last year, and this was an Austrian court ruling. There was an Austrian politician who obtained an order against Facebook prohibiting it from publishing a defamatory comment, or crucially anything identical or equivalent to that. So it went to appeal, and there ended up being a question referred to the Court of Justice, and the Court of Justice ruled that this didn't amount to a general monitoring obligation, which would be prohibited under the e-commerce directive. So this kind of broadening of takedown obligations, I mean, this was in defamation context, but it's certainly somewhere that brands could potentially push the law in this area. So you could say if a takedown notice has been issued against a particular good, then could there be an obligation for the marketplace operator to take down identical or equivalent goods? Yeah, potentially. It's one area where there might be an extension of the current law. So, in summary, what next? There's various possibilities, where the law could end up, and I think with Brexit on the horizon, there's even more possibility for divergence there. So, I think watch this space is the answer really, because there's definitely going to be more cases to come. So I think now we're just going to move on to any questions, and I know we have had one, so I'll just take a look at that now.
I was thinking, Joe, to just finish your slides and then to answer it. So the question that's been given to us is, the Coty case seems to rely on the fact that Amazon was not aware that the goods had not been approved for sale in the EU. How different could the decision have been if the court had looked at the liability if Amazon had been put on notice that the product should not have been placed on the EU market? I think it's like difficult with the question in that I think what that is that if you told Amazon, here is my product called widgets, it's not permitted to be sold on the EU market, you would still need an EU trademark in order to prevent Amazon from, or to get Amazon to stop using it, or to take it off, or to sue Amazon over. And if your product isn't for the EU market, then you wouldn't have that trademark. Otherwise, it's just a parallel importing. Unless you've got some differentiation that you could tell Amazon, here's how these products are differentiated, and then in a way that they could apply that quite easily without having a different trademark. Then I don't think that would make a difference. I don't think you could sue, but unless I've misunderstood the question. Joe, I don't know what you think. Oh, sorry, are you muted, Joe?
Yes, I am. Yeah, I agree with what you said there.
But yeah, I mean, if there is a real visible distinction between your products, and you have a trademark in the EU, and you could notify Amazon and say, look, I'm thinking sort of pharmaceuticals, but obviously that doesn't really get sold on Amazon. But if there was a differentiator that could be quite straightforwardly applied by Amazon, that might change things a bit. We've had some other questions. Given the marketplace's increasing role in managing sales, do you think we'll soon see legislation? I think, if you disagree with me, but I think we already have legislation on this, and I think Amazon and eBay and that lot would say we have.
I think the question was chopped in two then. So do you think we'll soon see legislation changes? There was mention of the copyright directives. What changes can we expect to see from that? So on the copyright directive, so the digital services or copyright and the digital services directive. So that is where there is it's kind of a removal of the prohibition on a general monitoring obligation, where you've got platforms hosting user-generated content. I mean, it does seem to be that the EU is pushing the law in that direction, certainly in the copyright context. So I'd be surprised if there was legislation from a trademark point of view which did something similar to remove the general monitoring obligation. But it does seem that the copyright in the copyright sphere is going that way, and the Facebook case that I mentioned, that the Court of Justice was quite happy to issue that broader takedown legislation. So it might be that things are kind of developing that way. I don't know if you have anything to add on that, Ollie.
No, not really. Obviously, the question, so there was mention of the copyright directive. What changes can we expect to see from that? That obviously only applies to copyright, and the article, I think, ended up at 17. It changed over the sort of course of its sort of trip through Parliament, European Parliament, that is, obviously. But that only applies to copyright. It really only applies to specific types of platform where they host user-generated content. Those questions, can you circulate the slides after, as we will? And then a point from my and Joe's colleague Steve in our trademarks team is just to point out that some companies have they use different barcodes outside Europe to cover that issue, and that is, I think, the point I was making before, is that it at least allows you to track whether those products have been put on the EEA market or not. If it's an EU barcode that's being sold on Amazon, then it's okay. And I think that's what Amazon is trying to get at with their Project Zero, Joe. I think the serialization option. Yeah, so I think there is an option for that, and if there's various ways of tackling parallel importing or grey imports, and that's certainly one of them. And then have we had any indication of where this could go post-Brexit in the UK? Not specifically on this point.
No, so certainly with the digital services, the copyright directive, the UK has said that it doesn't have any plans to implement it. That's assuming that we leave at the end of this year as currently timetabled. So that could potentially be a bit of a political stance to try and curry favour with US companies, the likes of Google and Facebook. And so kind of going along those lines, it might be that the UK would be more kind of pro-marketplace, pro-Amazon. But, that is pure speculation. And also, at least the UK lower courts will still be bound by Court of Justice rulings that happen before the end of the implementation period. So it will only be the Supreme Court that isn't bound. So if somebody wants the court to find differently from a Court of Justice ruling, then there would have to be an appeal all the way up to the Supreme Court, which could well happen, but it's not going to happen instantly. So, and obviously, Court of Justice rulings, once we have finally left, the courts won't be bound by. But anything that happens, or anything that has already happened or happens between now and the end of the implementation period, the UK lower courts will still be bound by. So, you know, there might be changes, but it's not going to be immediate.
I'd say that just to add to that, is that these cases are being applied. So there are Court of Justice cases that are were sort of that have already now been applied in the UK. So the Coffermel copyright decision, which I think we're going to cover in another one of these seminars, has already, so that's a Court of Justice decision, but it's been applied in the UK courts, and it will be, if to the extent that these decisions are applied by the UK courts, they become part of UK law as much as they are EU law, even though obviously they're based on European decisions. So you might find that these sorts of decisions are do form part of the UK law pretty quickly.
Are there any more questions? Silence. So I'm going to take that as a no.
Thank you so much for attending, and we've only dropped 10 people, and that was only in the last couple of minutes anyway. So hopefully people found it interesting. If you've got any questions or anything, we'll circulate the slides. Sorry, was that Joe?
I thought there was one more, but I'm not sure.
Well, I think it's just saying thank you. So we'll circulate the slides and a link. But yeah, so thank you very much for coming along. This is our. I think we've got one more. Sorry, hold on. One more. So I'm not sure I quite follow this. So I think this is about Amazon's awareness of it. So this I think is the safe harbor point. On the e-commerce directive. So once you've told them, they lose their knowledge. They're fixed with knowledge and have to take it down once you've told Amazon. Before that point, and that's what this related to really, is pre-getting the decision, is pre-notifying them of each thing. So it's trying to shift the burden onto Amazon to do some of the hard work. And then I think the last point was how much money did Coty waste for the sake of 41 bottles? I think that's a good point. Although I think it might be a point of principle. Coty's got history with Amazon, and there was another Court of Justice decision a couple of years ago because they prohibit all of their sellers, distributors from selling on Amazon for Davidoff hot water again. So I think it might be a point to prove. But yeah, so I think that's it. So thank you very much. And yeah, as I say, Joe and I are here if you want to ask some questions. And both of us, I hope you're all doing well in this crazy environment.
Yes, thank you very much, everybody, and yeah, keep well and stay safe.